Good evening everyone, welcome to Laexcellence IAS Academy. Today UPSC has successfully conducted UPSC Prelims paper 2025 and in this session we will be analyzing the polity questions that were asked from polity. Right, total there were 16 questions. There were 16 questions from polity, out of which a very well prepared candidate can attempt 11 to 12 questions correctly and 4 to 5 questions might be on difficult side. But if you compare this polity questions with 2024 paper, this year paper of polity questions are on difficult side if you compare with 2024 paper. In the last year paper, questions were straightforward, but this year you need to be attentive and you need to apply the logic while attempting the answers while answering the questions that were asked from polity, right? So we'll observe the questions. So we are seeing set B here. In set B, the first polity question was 51st question. It talks about panchayats. If you observe these three statements, the first statement it says that panchayats at the intermediate level exist in all states. But under the constitution, the intermediate level panchayats is not mandatory if the state population is less than 20 lakhs. So it is not existing in all the states. That you need to understand. Therefore, this statement is incorrect. And the second statement, it says that to be eligible to be a member of panchayat at the intermediate level, a person should attain the age of 30 years. If you observe, in the case of local bodies, the age for getting elected is 21 years. Nowhere with respect to local bodies, there is a mention of 30 years of age. So therefore, we need to eliminate option 2 as well. And what does option 3 says? It says that the chief minister of a state constitutes a commission to review the financial position of panchayats at the intermediate level. But if you observe article 243I, it is the governor of the state who will appoint state finance commission to review the finances of panchayats at all levels. So therefore statement 3 is also incorrect. And the question that were asked was, which of the following statements given above are not correct? So you need to focus on here, right? You need to observe that whether they are asking correct statements or incorrect statements. In this particular question, they are asking for not correct option and all the 3 statements are incorrect. So therefore answer is D, right? We will go to next question. The next polity question is question number 58. It says that consider the following statements about Lokpal. The question is about Lokpal, which falls under constitutional and non-constitutional bodies. This topic is very important. This year they have asked 2 or 3 questions from constitutional and non-constitutional bodies. What is the first statement that is given? It says that the power of the Lokpal applies to public servants of India, but not to the Indian public servants posted outside India. There is no such categorization between public servants posted in India and outside India. So therefore, this statement is incorrect. This law will be applicable to all the public servants whether they are posted within India or outside India. What does statement 2 says? It says that the chairperson or a member shall not be a member of the parliament or a member of the legislature of any state or union territory, and only the Chief Justice of India, whether incumbent or retired, has to be its chairperson. So if you observe here, they are saying that only Chief Justice of India, whether incumbent or retired, they can be the chairpersons. But if you see Lokpal Act 2013, it says that the chairperson can be a retired CJI or a retired judge of Supreme Court or any eminent person, eminent intellect who has a 25 years of service in anti-corruption as well as law. So therefore this statement is incorrect. The second part, which says that the chairperson has to be only a person who is a Chief Justice, incumbent or retired, this part is incorrect. So therefore statement 2 is not correct. And what does statement 3 talks about? It says that the chairperson or a member shall not be a person of less than 45 years of age on the date of assuming office as the chairperson or member, as the case may be. This is given in the act itself and the statement is correct. The chairperson or member, they have to be of 45 years of age at the date of assuming the office. And what does statement 4 says? It says that Lokpal cannot inquire into the allegations of corruption against a sitting prime minister. sitting Prime Minister, he is not outside the scope of Lokpal Act. He comes under Lokpal Act, but there are some restrictions. But the statement categorically says that he is outside the scope of Lokpal Act. So therefore the statement is incorrect. And what they are asking, which of the following statements given above are correct? And only option 3 is correct. So therefore answer is A for question number 58. The next polity question from set B is question number 66. It talks about the powers of the President of India. Right, we'll try to observe. What is the first statement? It says that the exercise of this power by the President can be subjected to limited judicial review. The statement says that the pardoning power of the President is subjected to judicial review. This was given by Supreme Court in many cases, including the famous Epuru Sudhakar case of 2006. In this particular case, Supreme Court said that the pardoning power of the President can be subjected to judicial review on the ground of arbitrariness. So therefore, there is a limited scope for judicial review, and the statement is correct. And what does statement 2 says? It says that the President can exercise this power without the advice of the central government. You have to observe here that under Article 74, the President does not have any discretionary power. He always needs to act according to the aid and advice of the Council of Ministers headed by Prime Minister. This was established by Supreme Court in Maruram case as well. In Maruram case of 1980, the Supreme Court has said that while using the pardoning power, the President has to act according to the advice of the Council of Ministers headed by Prime Minister. So therefore, statement 2 is not correct. It is saying that the power is without the advice of the central government, which is not true. So therefore, what they are asking, which of the following statements are correct? And only option A, that is one only, is correct. And the next question is question number 67. It talks about the office of Speaker. What does first statement says? On the day of dissolution of the House of People, the Speaker shall not vacate his or her office until immediately before the first meeting of the House of the People after its dissolution. Right. Article 94, it envisages that the office of the Speaker should be in continuation. So therefore, the sitting Speaker, he will not vacate his office on the date of dissolution of Lok Sabha, and this person, he will continue to occupy the office until the first meeting of new Lok Sabha after general elections. Therefore, this statement is correct. And what does statement 2 says? According to the provisions of Constitution, a member of the House of the People, on being elected as Speaker, shall resign from his or her political party immediately. There is no such provision in the Constitution of India. It is just a convention which can be followed, but it is not there in the Constitution. And why this convention can be followed? Because to ensure that the Speaker's office is neutral and impartial. To maintain that impartiality and neutrality, under 10th schedule, even if the person who is elected as Speaker, if he resigns to his political party, he will not be disqualified due to defection because he has resigned to his party. And that was there under 10th schedule to ensure, to protect the impartiality and independence of the Speaker. But there is no mandatory provision which says that he shall resign. If he wants, he can resign, but otherwise there is no mandatory provision. So therefore, this statement is not true. And what does statement 3 says? It says that the Speaker of the House of People may be removed from his or her office by resolution of the House of the People passed by majority of all the then members of the House, provided that no resolution shall be moved unless at least 14 days advance notice has been given to the intention to move this resolution. This is also there under Article 94. The process of removal of Speaker, he has to be removed by effective majority. That means the majority of the then members of the House. But to move that resolution, a 14 days advance notice should be given. And in addition to that, according to rules of Lok Sabha, 50 members has to support the resolution. Only then it can be moved and it can be taken up for discussion. So therefore, statement 3 is also correct. And they're asking which of the above are correct. And if you observe, statement 1 and 3 are correct and statement 2 is incorrect. Therefore, the answer is C. The next polity question in set B is question number 68. it talks about 10th schedule. So what does it says? If any question arises as to whether a member of the House of the People has become subject to disqualification under 10th schedule, the President decision in accordance to opinion of the Council of Ministers shall be final. So if you observe Article 102 Clause 2, which talks about anti-defection law, here the deciding authority is presiding officer of the House. If it is Lok Sabha, it will be, since they are talking about House of People, it will be the Speaker who will decide, not the President on the advice of the Council of Ministers. So therefore statement 1 is incorrect. And what does statement 2 says? It says that there is no mention of the word political party in the Constitution of India. Although no article of the Constitution talks about the term political party, but because of introduction of 10th schedule talks about political parties. Right. This particular schedule, it has a mention of political parties. Suppose if a member who got elected from a political party and if he resigns to his political party, then he will be disqualified under 10th schedule. So there is a mention of political party under 10th schedule, and this statement is incorrect, and the answer is neither 1 nor 2. And the next question, that is from Polity, is question number 69, and we will talk about the rights of the states with respect to minerals. This particular question has been asked this year because of the Supreme Court judgment that was given in 2024 regarding rights of states on minerals. It was a significant judgment which has given rights to the states regarding imposing taxes on mineral rights and mineral mining areas. And what does statement 1 says? It says that in India, state governments have no power for making rules for the grant of concessions in respect of extraction of minor minerals, even though such minerals are located in their territories. And minerals, according to MMDR Act, can be categorized into major and minor minerals, and when it comes to minor minerals, the state governments will have the powers to grant licenses and to fix royalties, etc. And this statement says that there is no such power for the state. So therefore statement 1 is incorrect. And what does statement 2 talks about? It says that in India, the central government has the power to notify minor minerals under relevant law, and this law is nothing but MMDR Act. Under this act, the central government has the powers to segregate or to divide a mineral into major mineral and minor mineral, and this statement is correct. And if you see, what is the correct option? The statement 1 is not correct, but statement 2 is correct. Answer is option D. The next polity question from set B is question number 81. It talks about the ordinance making power. So what does statement 1 says? An ordinance can amend any central act. So you need to remember that ordinance is nothing but a law of the legislature. Ordinance is nothing but a law of the legislature. It has the same effect as the law of the parliament or law of the state legislature, but it is of temporary nature. And it says that statement 1, an ordinance can amend any central act, which is true. A law can amend existing law, so therefore an ordinance can also amend existing central law. And what does statement 2 says? An ordinance can abridge a fundamental right, which is not true. So I told you that the ordinance is nothing but a law. A law cannot abridge existing fundamental rights. That power is not there with the legislature, right? But when you observe the amendment of the Constitution, the amendment can abridge fundamental rights without violating basic structure, but existing fundamental rights cannot be abridged by a mere law of the legislature. Therefore ordinance also cannot abridge. It cannot abridge. It says that can abridge, but this statement is not true. And what does statement 3 says? It says that an ordinance can come into effect from a back date. That means retrospective effect, right? Except criminal law, any other law can have retrospective effect. And I told you that ordinance is nothing but a law. It has the same features and same effect as the law of the legislature, and therefore ordinance also can have retrospective effect. And they're asking which of the above are true. And if you observe, statement 2 is incorrect. Therefore answer is C, 1 and 3 only. The next question is question number 82. It talks about states and the description given with respect to the state. And statement 1, it says it talks about Arunachal Pradesh. The capital is named after a fort and the state has 2 national parks. Here they have included environment also into polity question. Right. So you need to be aware of other subjects as well while adopting polity or any other subject. And when it comes to Arunachal Pradesh, Itanagar is after the name of a fort, that is Itanagar Fort, which is true, and the state has 2 national parks, which is also true, and therefore this particular matching is true. And the second matching, it talks about Nagaland. The state came into existence on the basis of a constitutional amendment act, which is not true. Nagaland came into existence because of Nagaland State Act. Nagaland State Act of 1962 passed by Parliament under Article 3. Article 3 empowers Parliament to create a state or to reduce the area of a state, to merge 2 different states or to alter the boundaries of a state. Under this power, Parliament has passed Nagaland State Act in 1962, and this is the basis for creation of Nagaland State. And if you talk about the basis of constitutional amendment, it is relevant to Sikkim. Sikkim has become a state under India under 35th and 36th Constitutional Amendment Acts. So therefore, the second matching is incorrect. And what is the third one? It talks about Tripura. Initially a Part C state, it became a centrally administered territory with the reorganization of states in 1956, and later attained the status of full-fledged state under Northeast States Reorganization Act 1971, which is true. The matching 3 is also true. And they're asking how many of the above pairs are correctly matched, and the answer is only 2. First and third are correct and second is incorrect. The next question is question number 83. It talks about how many of the above were established as per the provisions of Constitution. Right, one more question from constitutional and non-constitutional bodies, and they're asking how many of the above are constitutional bodies. Interstate Council mentioned under Article 263 is a constitutional body, but when it comes to National Security Council, it is a executive body. It is a executive body established in 1998. And when it comes to zonal councils, they were established under States Reorganization Act 1956. And this is based on a law of the Parliament. Therefore, zonal councils are statutory bodies. They are not constitutional bodies. National Security Council is a executive body and zonal council is a statutory body, and only interstate council is constitutional body. Right? And how many are established on the basis of Constitution? It is only 1, that is interstate council. And the next question is question number 84. Right, what does statement 1 says? It says that the Constitution of India explicitly mentions that in certain spheres of the governor of a state acts in his own discretion. When you observe Article 163 Clause 1, it says that there shall be a council of ministers headed by Chief Minister to aid and advise the governor, except in cases where the governor can act in his own discretion. Under Article 163 Clause 1, it specifically explicitly mentioned that the governor can have certain discretionary powers under the Constitution of India, which is true. And what does statement 2 talks about? It says that the President of India can reserve a bill passed by the state legislature on his or her own for his or her consideration without it being forwarded by the governor of the state concerned, which is not true. Right, when you see Article 200, the powers of the governor with respect to bills passed by state legislature, under this article, governor has a power to reserve a bill for the consideration of the president. Then the president will deal with respect to state bill according to Article 201. So president by himself, he cannot reserve a state bill for his own consideration. It has to come through governor, and therefore this statement is not true. And what is the correct answer? They are asking for correct options, and only statement 1 is true. The next question is question number 85. Right, they are matching some provisions of the Constitution with respect to the parts from which they were taken. What is the first one? It talks about separation of judiciary from the executive in the public services of the state, and it is mentioned under Article 50 under DPSPs, and this particular matching is true. And what the second one talks about? It talks about valuing and preserving of the rich heritage of our composite culture. It is a fundamental duty mentioned under Article 51A, which is also true. Prohibition of employment of children below the age of 14 years of age in factories, and which is a fundamental right under Article 24. And therefore, all these options are correctly matched, and the answer is all the three. The next question is question number 86. Right, with reference to the Constitution of India, if an area of a state is declared as scheduled area under the 5th schedule, right, we need to discuss about the scheduled areas. In these states, the state government loses its executive power in such areas and a local body assumes total administration. Right, even if you are not sure about this, can you expect a local body to be all too powerful in Indian system, which is not true. Right, in the case of scheduled areas, it is true that governor will be having certain special powers, and also local governments will have some rights or some powers. That doesn't mean the state government will completely lose its power. So therefore, this statement is not true. And what does statement 2 talks about? The union government can take over the total administration of such areas, that is 5th scheduled areas, under certain circumstances on the recommendations of the governor. If you observe, there is no such provision under scheduled 5 areas that the parliament, that the central government can take away all the powers with respect to these areas on the recommendations of the governor. This statement is also not true. The answer is neither 1 nor 2. They are asking for correct statements, and none of the 2 statements are correct. Right. The next question, it talks about organization and the ministry which it is related to. When it comes to National Automobile Board, it is under Ministry of Heavy Industries, and Coir Board, the coir industry is a MSME, and it comes under Ministry of Micro, Small and Medium Enterprises, and National Center for Trade Information, it is under Ministry of Commerce and Industry. And they're asking how many of the above pairs are correctly matched, and if you observe, none of the pair is correctly matched. So therefore, answer is D. The next question, question number 88, it talks about some of the subjects under Constitution, and if there has to be an amendment, with respect to which of the above, ratification by the legislatures of not less than 1/2 of the states is required before presenting the bill to the President of India. So where ratification of the states are involved, whenever there is a federal feature involved. So we need to observe which of the 3 features fall under federal features of Indian Constitution. And if you see list 1, union list in the 7th schedule, any amendments to 7th schedule, because 7th schedule talks about legislative division of powers between center and state. It has 3 different lists, union list, state list and concurrent list, and any amendments to this 7th schedule, it is a federal feature and there is a requirement of ratification of at least half of the states. So therefore, statement 1 is true. And statement 2, it talks about extent of the executive power of the state. Through amendment, if the center wants to reduce the executive powers of the state, that means the states are getting impacted. It is also a federal feature. Therefore, ratification by half of the states is required when it comes to executive power of the state. And statement 3, it talks about conditions of the governor's office. The conditions of the governor's office is mentioned under Article 158. It talks about his service conditions, it talks about his emoluments, it talks about his residence. And these features can be amended by the Parliament without any ratification, requirement of ratification of the states, half of the states. That is not required because these are service conditions of the governor's office and it does not essentially fall under the federal feature. If you are going to talk about the appointment or removal of governor, then it is a federal feature, but service conditions, it does not impact the rights of the states. So therefore, answer is 1 and 2. Statement A is correct. Right. Next question is question number 89. What does statement 1 says? It says that the governor of a state is not answerable is not answerable to any court for the exercise and performance of the powers and duties of his or her office. So there is an article, Article 361. It talks about immunities of the President of India and Governor of a state, and whatever they do in their official capacity, that cannot be questioned in a court of law, and therefore this statement is true under Article 361. And there is another provision under Article 361. It says that during his office, no criminal proceedings can be instituted or conducted against the governor, which is also true. When it comes to civil cases, they can be initiated, but by giving an advance notice of 2 months, which you need to understand. And statement 3, it talks about privileges of the members of state legislature, which is mentioned under Article 194. There are some individual and collective privileges mentioned under Article 194. And when it comes to this Article 194, members of a state legislature, they are not liable to any proceedings in any court in respect of anything said within the house, which is true. They have freedom of speech for whatever they have said or any vote that they have given inside the house. They enjoy that privilege under Article 194. So therefore, they are asking about correct statements, and all 3 are correct. Answer is 1, 2 and 3, that is D. And the last question in polity is question number 90, right? It talks about the activities of Petroleum and Natural Gas Regulatory Board, right? It comes under regulatory bodies, which is also under polity and governance, right? If you observe this Petroleum and Natural Gas Regulatory Board, it does not deal with production. For production, we have ONGC, etc. But this body, it talks about, it deals with refining, it deals with distribution, it deals with sales and marketing, right? We will observe the statement 1. It says production of crude oil. I told you that this particular body does not deal with production. And refining, storage and distribution, that is dealt by this particular body. Marketing and sale of petroleum products, it is dealt by this particular body. And production of natural gas, it is not dealt by this particular body. This particular board, it only deals with sales, marketing, as well as refinery and distribution, refining and distribution, but not production. And if you see, they're asking how many of the statements are correct, and answer is only 2, that is B, right? So if you observe, out of these 16 questions, 11 to 12 questions are doable for any serious candidate who has prepared polity very well, and there are 2 or 3 questions which you may not have covered, like this particular body. You may not have covered these particular bodies, but the other questions, the 11 or 12 questions which you can attempt with accuracy, right? Even with that, you can easily score 20 to 25 marks from polity. And I hope all of you will be successful in the prelims exam and prepare well for the upcoming mains. All the very best. Thank you.